Good morning, everyone. It's so great to be back in Sydney. I'd like to start, of course, by acknowledging the Gadigal people of the Eora Nation, the traditional custodians of this land, and pay my respects to elders past, present and future. Yesterday marked the anniversary of the Voice referendum, and I can't stand here and not exercise my free speech about what has been a very painful year, I know, for many First Nations Australians. Like many Australians, I was so disappointed by the outcome of the referendum and the opportunity that we lost as a country to move towards a more just Australia. But what was more devastating for me was to see the pain that that process has caused to so many First Nations communities. And I still hope that we as Australia can do better. The Uluru Statement was such a generous invitation to invite all of us to walk together towards a more just Australia. And I'm going to continue to use the platforms that I have, including here today, and the right to free speech that I have, to continue to raise awareness about the ongoing legacy of colonisation in our country and the ongoing harm it causes to First Nations people, including in our legal system. I'm continuing to devote part of my legal practice to First Nations justice, and I hope that all Australians will join me in doing everything that we each can to work towards a more just Australia, and my hope that we can do better can be turned into a reality. But I'm here today to talk about global challenges to free speech and what I'm seeing in my practice around the world. I'd like to say that it's a less relevant topic than ever, that free speech is protected and we don't have to worry about it anymore, but unfortunately what we're seeing around the world, and indeed here at home in Australia, is that these hard-fought wins, our right to free speech, our right to protest, are being attacked and undermined every day. This is going to set the course of our future, and the choices that we make today about how we react to it will determine the kind of world that we leave for future generations. And the question that I have is, what will that world look like, and what do we want it to look like? In recent times, we've seen how fundamental rights like reproductive freedoms in the United States have been taken away. And while I wholeheartedly believe with Martin Luther King that the arc of history bends towards justice, it's only if we continue to fight for it. Freedom of speech is one of the most fundamental of all rights, in my view. It's an important right in and of itself, but it's an enabling right. It allows us to fight for our other rights and freedoms. It allows us to live in a democracy and to fight for our democracy. Contrary to what some governments, including the New South Wales government, might have you believe, we also do have a right to protest, which is protected by our right to free speech. And now more than ever, we need to be able to speak up and protest about what's happening in our world and what's happening here in Australia. Whether we talk about war crimes and human rights violations happening in conflict zones and our government's complicity in those violations, or whether we talk about climate change and the criminal inaction of our governments to properly mitigate the disaster that we face, whether we talk about the epidemic of violence against women and girls and the failure of our government to take adequate action to protect us all from that scourge. But far too often we're seeing the criminalisation of free speech, of protest. Too often we're seeing people bankrupted, jailed, and even killed for exercising their right to free speech. I want to talk about a few examples today that I'm seeing in my work that have come up in the cases that I'm involved in. Now, I'm sure many of you want to hear about Julian Assange, and I won't disappoint. I'm sure many of you came because of Julian Assange. And I want to just talk a little bit about his release and why that's such a bright spot in such troubling times. I was Julian's lawyer for more than 14 years, and touching down in Canberra with him on that plane a few months ago was a remarkable experience. In fact, it couldn't have been a more Australian welcome. Just as we were landing in Australia after a very tense time in court in Saipan, in the North Mariana Islands, which I am sure, like many people around the world, you will have had to Google to find out where we were going. As we were touching down, the Wi-Fi on the plane was still working, and my dad FaceTimed. And like most older generations, my dad's a horse farmer. He did that thing that most of our parents do where he sort of popped up on the screen and you could see nothing but his bald head. And I could hear him say, "Oh, good on you, Dal. We're so proud of you. About time. This is wonderful. How are you going?" And I was like, "Great, thanks, Dad. We're actually just landing in Australia. I'm sitting here with Julian." And I held the phone up, and Julian was like, "G'day, Terry." And my dad was like, "Oh, good on you, mate." Just as we touched down, I was like, "Dad, I've got to hang up." And the next phone call was from the Prime Minister Anthony Albanese, who got on the phone to welcome Julian home. And it was really wonderful to see them speak. I held up the phone so the Prime Minister could speak to Julian. And the Prime Minister welcomed him home, checked in that he was okay. And Julian said to him, "I want to thank you. You've saved my life." And I don't think he was wrong. For more than 14 years, Julian was placed under all forms of restrictions of his liberty: house arrest, prison initially, then house arrest, and 7.5 years in the Ecuadorian embassy, 5.5 years in a high-security prison for publishing evidence of war crimes and human rights abuse the world over. For the same publications for which he's won journalism awards the world over and been nominated for the Nobel Peace Prize each year since those revelations. Evidence of war crimes in Iraq and Afghanistan, evidence of US corruption and human rights violations around the world. But his release and the plea deal that we were able to negotiate was a huge win. In effect, he pleaded guilty to committing journalism and award-winning journalism. And in court, the US government had to acknowledge that there was no harm caused by those publications. I think our return home to Australia was such a positive story also. I was overwhelmed by the well wishes from people. I was getting stopped on the street. In restaurants, people would recognise me and send over bottles of champagne to say thank you and congratulations, which, by the way, may continue and keep them coming. But just knowing that Julian's at home with his family, with his kids, with Stella, and enjoying the Australian beaches and landscape that he missed so much when he was in prison, that we talked about so much over so many years, is one of the most rewarding outcomes in my professional career. And I think it was so positive because people were looking for hopeful stories in dark times, that in fact that you could take on the world's most powerful government who was trying to send you to prison for the rest of your life, and you could win, because that was a win. The only reason Julian was released is not just because of 14 years of legal battles and the many brilliant lawyers that I worked with around the world to defend him and challenge that extradition request, but also because of the community support and the campaigning here in Australia. The individuals and communities that campaigned, called their MPs, pressured the government to come to this position. It's because of that global movement for free speech that made it politically impossible for the United States to continue doing what they were doing. And it was the diplomacy and the principled leadership of our Prime Minister that enabled the negotiations that resulted in that very, very important outcome. But the fact that Julian was prosecuted at all is a terrible precedent and should be troubling for journalists and publishers everywhere. What the United States is doing with the law, and the law as they exist on the books in the United States today with the Espionage Act, is exercising extraterritorial criminal jurisdiction to any journalist and publisher around the world who publishes information about the United States, about US war crimes, while not offering them constitutional free speech protections. So if you are a French journalist in France, as Julian explained to the Council of Europe just the other week, if you're an American citizen in France, you will have First Amendment protections, but if you are a French citizen in France publishing this information, you won't have those same protections. And that is troubling, because the reality is that the law on the books in the United States criminalises journalism. And Julian may well have been the first journalist prosecuted under the Espionage Act, but depending on what happens with the US election, I don't think he will be the last. The important thing to remember, though, about the deal that we did, not only did it secure Julian's freedom and his ability to travel around the world, I still have to pinch myself when I see images of him in France on a train with his kids doing everyday things that he couldn't do for so long. But the law on the books remains in place, and others could face prosecution. And this needs to change. It needs to change because I, for one, don't want to live in a world where people like Julian go to prison for publishing evidence of war crimes while those responsible for the war crimes don't face accountability. We need to continue to stand up for people who, like Julian, are being targeted and published for telling the truth about war crimes. Now, he set up WikiLeaks and published what he did about US wars because he believed that if the public was to know the truth about unjust wars and saw the consequences of those wars and the human suffering in those wars, that we could work to end those unjust wars. And unfortunately, as we enter the second year of the war in Gaza, those lifting the lid on the horrors of this conflict are being targeted at unprecedented rates. There have now been more Palestinian journalists killed by Israel in the past 12 months than there were journalists killed during both World War II and the Vietnam War combined. And in fact, Israel broke that terrible record in the first 2 months of the conflict. As the war now spreads to Lebanon, the civilian death toll and the number of journalists being killed is only going to climb. And the reason I talk about journalists and why I think journalists are so important is because of the important role they play in wars, to show us the truth, to hold governments accountable for war crimes. Journalists are civilians. That's why they wear press vests, to make it very clear that they are not combatants and that they are there to document, not to fight. Deliberately targeting a journalist is a war crime. And as I've explained it before, I think it's a war crime upon a war crime, because it's a war crime directed at trying to stop the reporting of war crimes and holding governments to account for the war crimes they commit during the conflicts. Killing journalists prevents us from getting the information that we need as the public to hold governments to account and to end these unjust wars. But for many years, my colleague Tatiana Eatwell from Doughty Street Chambers, where I practice in London, and I have been working with the Palestinian Journalist Syndicate and the International Federation of Journalists, trying to hold Israel to account for a pattern of what we've seen of the deliberate targeting of journalists. We made our first submissions to the International Criminal Court back in 2021, calling for an investigation, and the ICC took no action. When the killing of renowned Al Jazeera journalist Shireen Abu Akleh captured the world's attention in 2022, we filed another complaint, this time for her and her family, calling for an investigation. And still, the ICC did nothing. We continue to argue that the ICC's failure to take proper action against Israel has enabled ongoing impunity and further attacks on Palestinian journalists. By the time the ICC finally opened an investigation into the targeting of journalists earlier this year, more than 120 journalists, Palestinian journalists, media workers had been killed in Gaza. Now, the ICC rightfully rushed to prosecute cases involving the Ukraine, but for far too long remained silent on Palestine. While the prosecutor has now requested arrest warrants in respect of both Israeli and Hamas leaders, we want the deliberate targeting of journalists to be included in their alleged crimes. This year on World Press Freedom Day, our client, Nasser Abu Bakr, accepted UNESCO's highest journalism award on behalf of Palestinian journalists in Gaza. In granting that award, the jury chair emphasised that, and I quote, "We owe a huge debt to their courage and commitment to freedom of expression." And we do indeed. And journalists, whether they're Palestinian, Lebanese, Ukrainian or Australian, should not have to pay for that commitment with their lives. I want to pause here to also remember another of my clients, Issam Abdallah, the Lebanese Reuters journalist who was killed by Israel in southern Lebanon a year ago this week. He and his family also deserve justice. There were 2 Israeli journalists killed by Hamas on October 7. Since then, the International Federation of Journalists is now reporting that as many as 130 Palestinian journalists have been killed. The Committee to Protect Journalists has found that at least 5 of these journalists were deliberately targeted and are investigating at least 10 more cases, and we continue to do the same. But how many more of these journalists need to be killed before the ICC takes action and prosecutes those responsible? We are continuing to work with our clients to submit evidence to the ICC in the hope that they will take action, because the rates of journalists being killed is unacceptable. But killing is the ultimate act of silencing. There are many other ways that people are being silenced or chilled into silence after seeing the consequences that others are facing, including here in Australia, for speaking out about Gaza. It's been really interesting to me after recent media appearances in Australia, where I've spoken about what's happening in Gaza, and I've been inundated with comments from people telling me how brave I am. And my reaction was, well, brave for what? For talking about the fact that the International Court of Justice has found there's a plausible case that Israel is committing genocide? For talking about the fact that the ICC prosecutor is now seeking an arrest warrant for Netanyahu? Is it really that brave to express my opinion that it is wrong in principle for an ABC journalist to be sacked for sharing a Human Rights Watch report, and a report that the ABC itself had reported on? Now, that is my principal position, whether we're talking about Gaza or Ukraine or Russia or any other part of the world. But the fact that people think it's brave to state these facts or to express what I think is a pretty reasonable opinion goes to show just how fraught free speech on Gaza is in this country. And of course, it was Antoinette Lattouf who was sacked by the ABC for sharing a factual post from Human Rights Watch which set out Israel's use of starvation as a weapon of war in Gaza. This was a finding that the ABC had in fact reported on, and indeed now forms part of the basis for the ICC prosecutor's request for an arrest warrant. And yet she's still tied up in legal action with the ABC. What an excellent use of taxpayer funds. The pianist Jason Gillam recently had a performance cancelled by the Melbourne Symphony Orchestra, which came after remarks he made while performing a piece which he dedicated to Palestinian journalists in Gaza, a piece he'd called Witness. From what I've read, his remarks are very similar to what I had to say here on the stage. And Gillam's now recently had to launch a legal action to defend his freedom of speech and the ability of artists to perform without fear of censorship, in his words. But what we're seeing happen in Australia is happening around the world. The UN Special Rapporteur on Freedom of Expression has just reported to the UN General Assembly, and in her report she said that the conflict in Gaza has unleashed a global crisis for free speech. She reports that anti-Semitism, Islamophobia, and anti-Palestinian racism have surged, while confusion over what actually constitutes anti-Semitism, poorly drafted laws, and vested political interests have undermined both free speech and efforts to tackle hate speech. And I want to make clear, there is no place in our society for anti-Palestinian racism or anti-Semitism. But we cannot allow these labels to be misused to chill speech about war crimes and about human rights violations. I want to devote the rest of my time today, and hopefully we have a bit more time, to the issue that I am so passionate about, which is free speech about gender-based violence, one of the most prolific human rights violations in the world. The statistics in Australia are shocking, and I think you've all heard them, but I'm going to say them again. 1 in 3 women will experience physical violence in their lifetime, 1 in 5 sexual violence. Indigenous women, women with disability, and LGBTQ women experience violence at much higher rates than that. If you think about the people sitting in this room, and I'm sorry, I know this is triggering, that is a lot of people. What's even more shocking is that the figures are getting worse. Our Sex Discrimination Commissioner, Dr. Anna Koda, confirmed in July this year that male violence against women is in fact increasing. We're seeing an epidemic which generates headlines with depressing regularity. There was one point earlier this year when a woman was murdered every 4 days in Australia. But that's not just happening here, it's everywhere. But not all men, they say, not all men Well, the figures dictate that it's actually quite a lot of them. Last month it was reported 1 in 10 men in New South Wales have been reported to the police for domestic violence. 1 in 10, and that's just what's reported. To understand the pervasiveness of rape culture in our society and in this country, we need only look to the huge success of Chanel Contos's Teach Us Consent campaign and the immense numbers of young women that came forward anonymously to tell their stories of rape and sexual assault. And in many ways, the legacy of the Me Too movement has made gender-based violence more visible. Women have been breaking this cultural silence, speaking out about their experience. But what we started to see in our practice and what I was seeing in my practice was a legal backlash. The use of legal tools, non-disclosure agreements, defamation proceedings, weaponising the law to silence women and reinforce the status quo, silencing not just women but journalists from reporting on these issues. The issue became so big, and I want to tell you a story about one of the cases that sparked our decision to write a whole book about it. Was a case called Stocker and Stocker in the United Kingdom. This was a case involving a woman who had written on her ex-partner's new partner's Facebook wall. Does that make sense? And on it, they had a discussion about his history of violence. And she wrote, probably mistakenly on her Facebook wall, not in a private message, but there we are, for her friends and family to see, that her new partner had in fact been violent towards his ex. And she talked about the time he tried to strangle her and that the police don't take too kindly to seeing a woman with red marks around her neck. Her ex-partner then sued her for defamation. It went before the courts in the United Kingdom, even though something like 10 or 11 of his new girlfriend's friends had seen the post. And even though she had evidence that the police had in fact seen red marks around her neck an hour after the incident, the judge found that was not sufficient to prove the truth of her allegation that he had tried to strangle her. And why? Because the technical definition of strangulation requires an intent to kill. And I will quote the judge, "In finding against her, in silencing her, and in awarding damages against her for speaking the truth about her experience of domestic violence, he said he couldn't find in her favour because he wasn't satisfied that Mr. Stocker had intended to kill her. His intention was to silence her, not to kill her." This, of course, caused consternation amongst free speech and domestic violence groups because strangulation is first and foremost a sign of escalation of domestic violence and often is a sign of what's worse to come, and women are murdered afterwards. But the fact that this woman had evidence and still couldn't prove the truth, she was still found to have defamed him. It took her 7 years fighting all the way up to the UK Supreme Court before the Supreme Court found that that was an illegitimate restriction on her right to free speech. We had watched this, that many of the key cases, like Stocker and Stocker, that were finding their way to the Supreme Court of the United Kingdom, all involved defamation cases involving domestic violence. What does that tell you about the post-Me Too world? We tried to intervene in that case to say to the judges that we're looking at this from, when you think about the public interest, when you've got the most prolific human rights violation in the world, we have to protect women's ability to speak about their experiences of violence. We need to look beyond just his right to reputation and her right to free speech. What about her right to be free from gender-based violence, her right to equality? But the Supreme Court didn't want to hear us. So we went and wrote a book about it. And I'm pleased to say that courts around the world are starting to listen to these arguments. The Constitutional Court in Colombia has just upheld that same argument to protect women in speaking out on social media about their experiences of rape and gender-based violence. But if we look at what's happening in Australia, when the Me Too movement started in Australia, there was a raft of defamation claims by high-profile individuals: Geoffrey Rush, Craig McLachlan, Don Burke. The list goes on, right up until the most recent, Bruce Lehrmann. Many questioned whether defamation claims were stifling the Me Too movement in Australia. We need only look at the case study of Brittany Higgins to think about how defamation claims can limit public interest discussion. There is no doubt that Brittany Higgins speaking out about her rape, which Bruce Lerman still denies, note that I've got that in there so I don't get sued for defamation myself. The fact that she spoke out about her rape that was proven true in a defamation case, as found by Justice Lee, it clearly was a matter of public interest that could happen in Australia's federal parliament. What's happened since her decision to speak out? Legislative change, workplace reforms to better protect women not just in Parliament but elsewhere. The March for Justice protests where women came out across the country saying this is not good enough, we have to do better. And yet, as a result of Brittany speaking out, at my last count, there have been more than 14 separate defamation claims just arising from her decision to speak out and the various things that have happened around it. 14, including Bruce Lerman's cases against the media. What message does that send to women? What we've seen happen to Brittany Higgins, the failure of the criminal justice system. I remember sitting there the day that the jury was discharged and she gave that powerful speech outside of court, which she was threatened for criminal prosecution for, by the way. And I remember a text message popping up on my phone from a friend saying, "Jen, this is exactly why I never reported my rape." We have to do better in the criminal justice system, but it's not just what is happening and the failures of the criminal justice system. It's what's happening in our defamation courts. The fact that Channel 10, for reporting the truth about a rape in Parliament, had to spend hundreds of thousands of dollars, likely far more than that, I can't remember how much it was, it could have been into the millions, to defend Brittany's truth. What other journalists are going to report on stories like this if they don't have the legal budget, or if they're at risk of costs of that magnitude for reporting on gender-based violence? What woman will speak out if she has been sued or been forced to give evidence, not just in a criminal trial, but now in a defamation trial, broadcast live online to more than 70,000 people at my count, giving evidence about her rape? If that had been a criminal trial, she would not have been forced to give that evidence live online. There is no way that would happen. So even though we're seeing more of these allegations of gender-based violence turning up in our civil courts, in defamation trials, the same protections that we've had for women in criminal trials that have developed over many years of criminal trials about gender-based violence, about rape and domestic violence, do not exist in the same way in the criminal justice system. To give you one example, we acknowledge in the criminal justice system that male-centric tropes about gender-based violence, why didn't she just leave him? She must have been asking for it. Was she drunk? What was she wearing? Victim-blaming attitudes deny women justice in criminal trials. Because of that, juries get directions from a judge asking them to ignore that, asking them to ignore stereotypes of what represents a perfect victim or someone who looks like a perpetrator, to reject these male-centric tropes about gender-based violence. We do not see that in defamation trials involving juries. It was these issues, long before Brittany Higgins' case came along and long before Amber Heard's case came across my desk, that made us want to write this book. Far too many women were coming into our offices with stories of being sued. Far too many journalists that I was working with were spiking stories because they could not get it across the line. Either their newspaper did not have legal budgets to report these stories, or the editor wanted to know how many more women had accused him. One woman wasn't enough. They needed more evidence. In a criminal trial, one woman's evidence is enough, but somehow to get a story across the line in the newspaper, you need more than that. And so what you see in the public domain of these high-profile defamation cases is just the tip of the iceberg of what we were seeing, and the self-censorship. Most women, and indeed journalists who are threatened with defamation, will choose to self-censor rather than go through the cost of defending a defamation suit. That is a fact. But you won't see that. So there's so much more silencing than we talk about, and we're able to talk about in the public domain. The reason we wanted to write this book is that allowing women to speak about their experience of gender-based violence is a matter of public interest, because if we can't understand the extent of the problem, how can we ever begin to grapple with it? How can governments make policy? How can they properly fund it if we can't talk about it? What we show in our book is that this is happening not just in Australia, not just in the UK, not just in the US. It's happening all over the world. There are spectrums of violence, there's spectrums of silencing, but irrespective of jurisdiction, geography, religion, ethnicity, women are being silenced by the law. And that goes to show that it's about gender and it's about power. I want to give us enough time to have questions, and we've got Nerelda who will probably ask you all the questions that you are dying to ask. But the last thing I want to say about this is that this is also a cultural question. As someone who represented Amber Heard in the Johnny Depp defamation proceedings in the UK, where we proved that he was violent towards her on at least 12 occasions, including sexual violence, most of you probably don't remember that there was even a UK trial, or the fact that we proved that he was violent towards her and that she is a recognised victim of domestic violence in the UK. Because the US trial was everywhere, beamed into our phones, all over TikTok, all over Instagram, millions and millions, in fact billions of hits, justice for Johnny Depp. Everyone seemed to have an opinion, Team Johnny, Team Amber, without actually looking at the facts. And as someone who spent 2 years working with her on that evidence and helped prove his violence in the UK court, it was really difficult to watch this play out in the US and see a jury without the directions they ought to have about male-centric tropes about gender-based violence find against her. But what was most interesting, I think, was society's reaction, what we saw online, the wave of misogyny unleashed online, the public discussion. Everyone had a view, everyone was Team Johnny or Team Amber. And the point I'd like to make before we close is neither Amber or Johnny will ever hear what you had to say, but do you know who will hear about it? Who might have heard you say she's crazy, she's a liar, why would anyone believe her? Is the woman that you know who hasn't spoken out about her experience of gender-based violence. And will she come and talk to you, having heard the way you spoke about that? So this is not just a question of free speech, it's a cultural question, and I ask and urge everyone to think about it more carefully and to do what you can in your own sphere of influence to change the culture around this in the hope that we can have a better conversation in Australia and better protect women to come forward. Thank you.
Jen, thank you so much. Let's take a seat.
Great.
Jen, I'd like to pick up where you left us. When you pass a billboard of Johnny Depp, and there are many selling, fragrances and things, what do you think?
I find it, and those billboards remained up even after the UK trial, before the US trial, when we'd proven in court that he had been violent towards her. And this huge billboards as I walk through Heathrow with savage. When there's evidence in the case where he called himself a, excuse my language, fucking savage after an incident that we proved in court that he had hit her. So to see that kind of commercialisation, when you've had Dior remove ads about Johnny Depp for misappropriation of Native American culture, but you don't see them remove ads in respect of violence against women, I think it raises some pretty serious questions, I think.
Is that symbolic of where we are at as a society, where, somebody like Amber Heard may never work again, but he's there on billboards? I'll also take you to some comments back in court with Bruce Lerman fighting for costs, and his lawyer mentioned that the only hope he has of making any money is to start an OnlyFans account. What did you make of those comments?
Well, no one wants to see that, to start with. Look.
But the fact that OnlyFans was mentioned when they're talking about something incredibly serious.
Exactly.
And after what we've just heard about him being proven.
The discussion in the Australian media and frankly in court yesterday in the appeal hearing about what is an incredibly serious and traumatic incident of rape for a woman that was accepted by Justice Lee She finally got the vindication she deserved. You know, as Justice Lee said, he stepped out of the lion's den and went back for his hat. That goes to show, I think, is a cautionary tale for any man seeking to sue on a criminal allegation. If you haven't faced criminal prosecution to the highest standard of proof and you want to take the risk on a lower civil standard, then that's the risk you take. But it goes beyond, I think, what happened in the courtroom. It's also what's happened in the media and the discussion in the media in Australia. The victim-blaming attitudes we saw directed at Brittany Higgins and, frankly, other women that spoke out. Social media, the attacks that we saw, not just on her, including involving criminal complaints because of the threats made to her, but the threats that Amber Heard's had, the threats that I've had, rape and death threats for simply defending a woman and defending her speech about gender-based violence.
I particularly like the part in your speech where you talked about her right to free speech is about so much more than free speech. It's about equality and it's about existence. So are we still so backwards in terms of protecting the systems or upholding the systems that protect men?
Well, yes, and we have a whole chapter in the book, Laws Written by Men for Men, which explains how the architecture of the law has been set up in that way. And I think this is the thing that people need to realise when women speak out about gender-based violence, and we talk about this in the book. There's this sort of feeling after Me Too that you can say whatever you want, but actually the law regulates what you can say, who you can say it to, and when. From the moment that you are raped or suffer physical violence, what you can say, who you can say it to, and when. And that's why we wrote this book, because we wanted women to be aware of this and the way it can be weaponised against them. And we want to empower women to make better decisions so that they speak out in safer ways and understand and access the resources they need to be able to talk about it.
The book has been published again, unredacted and uncensored. Can you just explain why did you have to redact a section of it and why has it been republished?
We published the book. We were due to publish the book after the Lemon criminal trial. Because it was delayed because of the contempt issues that arose, we actually published at the same time as the trial, and all of us were directed by the court after Lisa Wilkins-Logie's speech that we weren't to discuss Brittany Higgins at all. And most books that were coming out at that time, including Julia Gillard's book, Not Now, Not Ever, removed all reference to Brittany Higgins. Now, I found that a huge... To me, I thought that contempt ruling went too far. Contempt is about not stating someone's guilt before they've been proven to be guilty in court. Now, we can all do that while still talking about the facts of a case. But we didn't want to remove it. We thought, we're not going to do that. We want to show people in a very visceral, immediate way. And I wish I had the old version of the book to show you. But we redacted it, like you would get sort of classified documents back from the government where they black out what you're not allowed to read. We blacked out everything about every reference to Brittany, so that you could see that even we were being silenced by the law. We couldn't talk about it because of the contempt laws designed to protect his right to presumed innocence, which also, by the way, prevented us from talking about the other women that came out at the same time as Brittany did after she spoke out, including allegations of sexual assault. All of that was taken from the internet because of the contempt risk once he was charged in Brittany's case, and then the subsequent cases that he now faces in Queensland happened while he was on bail facing a rape trial in Brittany's case. So the effect of contempt laws was to remove all reference online to repeat allegations against him. And I think women ought to know that information, frankly. I want to know before I put myself in a room with a man.
Jen, I want to move on to Julian Assange. What is he up to now? Is he enjoying life? We all saw that he popped up and made some very public comments just recently with and Stella and the boys. How is he?
I actually haven't seen him in person since we got off the plane. We sort of took two cars. There was a decoy that took him to where he is, and I'm really pleased the media is respecting his right to privacy so that he and the kids and Stella can take their time to, get to grips with life and that he can recover in privacy. But yes, he took off in one car and Stella and I went in another car to the press conference, and we were sort of hounded by the media thinking he was with us. So I've just been getting text messages from him, and hopefully I'll see him soon now he's back from Europe. But he's enjoying the beach, he's enjoying being in Australia. And they were the toughest times for me when he was in prison in the Ecuadorian embassy, because I come back and forth from Australia a lot because, you know, we're both Aussie and we miss home. And he would always want to hear from me stories of like the bushwalk that I did or the beach, or to tell him scenes of the things that I'd been able to do. And it was so sad that I was able to do this and he couldn't. So to me, it's just so happy to see images of him and the kids on the beach. And it gives me a lot of joy. But I mean, look, as he said in Parliament last week, he's still not recovered. And I don't know if you ever can recover from that experience.
I will always think of you in that moment of utter joy, pure bliss when you arrived with Julian, and the moment that the family reunions were taking place and you were just there in the background, just holding your heart. It was just such a beautiful moment. And the next day you did the media rounds. Oh, actually that night as well. Of course, it was just huge. Did anybody watch live that media coverage that evening? It was. What you saw on screen was only a fraction of what was going on behind the scenes.
It was a circus. It was unbelievable. So we went back to do this press conference. Now, bear in mind, this is every woman's worst nightmare, I think. I had been travelling by that point for about 3 days. I'd barely slept. So what people need to realise, like Julian was taken from prison at 2 a.m. on Monday morning in a police operation to get him to the airport. I started at 6 a.m. with the High Commissioner. We were in the airport, I mean the most absurd of circumstances, in the private jet terminal at Stansted as Taylor Swift's entourage is coming through.
Oh, wow.
They had to hide us in a room so that no one would see Julian. But this was all kept under wraps. And so we were in that terminal for 12 hours before we even took off to Bangkok.
Was Taylor Swift your decoy?
Well, I don't know if the police organised it that way, but we were on her jet that she chartered from Japan to the Super Bowl, apparently, which I found out many days later, because obviously I didn't have time to watch the news. I was too busy dealing with what we were doing. And everyone was like, do you know you're on Taylor Swift's jet? I was like, is that really the fact that people are most taken by in this circumstance? But, you know, it was 12 hours in the airport, a flight to Bangkok. Stephen Smith and I, like this, trying to sleep on a seat rolled back before we got down to Saipan. We're in Bangkok for like 8 or 10 hours before we flew to Saipan, straight off the plane into court. I'd barely slept. We were doing this very high stakes hearing. We didn't know whether the judge was going to accept the plea. And of course, we had made plans for it. But Julian, having fought for 14 years to not go into a US jurisdiction, to fly into a US jurisdiction with him, was nerve-wracking to say the least. Then to go out and do a press conference in front of the world, then get on another plane, come to Canberra, do another press conference, and by the time we got to the press conference in Canberra, supporters and protesters had figured out where we were doing it, and the hotel was just rammed with people. I could barely hear myself give that press conference at the end. So I think I'd got 8 hours sleep in 4 days at that point.
It was great to watch you actually just command the room and just pause
Tell
for a moment and just be like, yeah, exactly. And it was great to watch it live. It was just a real moment. And then the following day you were in Canberra in Parliament House doing the rounds of the press gallery. And that's where I was able to interview you and Stella. And there was not even a thought in my mind that I would ask you, you know, with your beaming smiles, so happy on a cloud nine, does, you know, the question of does what happened to Julian lay a cloud over what is actually journalism? Was the actions of Julian Assange on WikiLeaks actually public interest journalism? Because that was an issue that was bubbling underneath the whole time.
Yeah.
But there were journalists that did ask you and have been asking you since then. So where are we at with journalism in this country that people are still asking in the moments that's not the thing that should be asked. The thing that should be asked is Julian is free, and how did you get him free, and what does this then mean for public interest journalism and the future of journalism and free speech?
Well, it just astonishes me that people are still asking whether that was journalism. How many journalism awards does he have to win from his peers before people will accept what he did was journalism? And in the end, that whole debate of whether or not he's a journalist is a complete red herring, because free speech protects journalistic activity. The First Amendment protects everyone, whether you're a journalist or not, whether you're labelled a journalist or not. And what he did was absolutely journalistic activity. And the fact that we still have to have that fight with certain journalists and certain sections of the media is astonishing to me. And as I always said, The journalists that denied this and tried to other WikiLeaks were shooting themselves in the foot because they felt that, well, if we say he's not a journalist, then what's happening to him won't apply to us. Then, of course, we had the Trump administration, where it was clear that that is exactly what they were going to do with this precedent. And I don't know how often I have to appeal to journalists' own sense of self-interest. Why do you not want to stand up and protect your own protections? It's astonishing to me.
What is public interest journalism then? And are we censoring journalism in this country, is particularly at public broadcasters?
That is a very big question.
And then commercial networks who don't have the same, not quite the same rules that apply to the public broadcaster, still will then, just regurgitate what they're hearing from politicians without too much interrogation.
I think it's a real problem with investigative journalism, the cut to budgets and legal budgets, which are desperately needed. If you're doing your journalism well, you're going to be threatened either by the government or by powerful individuals for what you report. And I think the financial pressures on journalism is having a massive impact on the risks that journalists are willing to take. And let's be frank, Julian published without fear or favour, and because he published what, those publications shook the world's greatest power, the United States, to its core. That's why they went for him. And very few journalists are brave enough to do that. But we need journalists like that. We need journalists who are willing to stand up and publish that material. And lawyers who are willing to defend them. Yes.
This time of the year is a very challenging time of the year for a lot of people around the world because of the anniversaries. So October 7, the obvious anniversary there. And then just yesterday, thank you for opening your speech by talking about the Voice referendum. There are journalists that are reporting the truth. And this whole notion of both sidesism has come into play in quite a big way, particularly during the referendum, coverage of the referendum, and now the Israel-Hamas war and everything that's come from that. I just wanted to mention just very specifically something that happened between Peter Dutton and a young journo at the ABC. I'm not sure if you're aware of it, so I'll just fill you in. Anushree Sood is her name, a great journalist at the ABC, and this was after a week before the anniversary of October 7. There was huge rallies in Sydney and around Australia, and there were Hezbollah flags being waved in mourning, in grief of the leader that had just been killed the day before. And so Anushree Sood legitimately asked Peter Dutton, what has Hezbollah done to make it be classed as a terror organisation? And instead of answering the question, he attacked the question here, and he attacked the ABC and her. He personally attacked her. So this was, the leader of the opposition going against a young journo. The ABC didn't defend her and said that it was wrong for him to be asked it. But is it a legitimate question? Are these legitimate questions that we're asking of our leaders?
Of course it's a legitimate question. And if it was so given that she shouldn't have asked it, then why couldn't he have answered it? If it's an easy question, why can't you just answer it?
When people tell you that you're brave for saying things that you do, like on Q&A and other interviews, and you're just shocked at being brave.
It's not brave.
Why are we so scared to say the truth? And like you say, when the ICJ and ICC are making allegations and saying that there are the facts there to back it up, why aren't we then acting upon international law?
It's a great question. It's why I'm a lawyer. I stick to the law. I talk about the law all the time. And to me, talking about the truth about what's happening and talking about facts like what international institutions have been finding about what Israel is doing, why can't we talk about that? But I think, as I said earlier, I think there's a real issue about the consequences we're seeing people suffer for speaking the truth, whether you talk about Antoinette Lattouf or others. And I think we need to create a safer space to talk about this, whether it's about Gaza or about any other conflict. And I think it's really important that we don't have double standards about this. So the threat to free speech that we're seeing globally, and I'm not just saying this from my own perspective, this is the UN expert has written a full report about the global challenge to free speech caused by the conflict in Gaza, which has just been published and is being presented in the UN General Assembly this week. But it's published, you can read it. It's really troubling. And frankly, this is how impunity happens. If we can't talk about it, this is how impunity is fostered and human rights violations continue. We have to be able to talk about this. Our international institutions have to be able to hold powerful leaders to account.
And when we see the way that protests are reported in this country, you would think that Australia has an issue with people protesting. It's a real us and them. It's like it's a certain type of person that protests, and that certain type of person is not me. You know, that's the how do we break that kind of thinking, and how do we want to understand why people are protesting? Because there's not really that kind of level of wanting to understand.
Well, I think there's just such a divisive conversation in Australia. Honestly, I've been opening the newspaper since I got home from the UK this last week, and the reporting has been so divisive, so polarising, and I think that's really problematic. We need to talk about where everyone is coming from. We need to have we need to be open to having these conversations, because that's where we find common ground and we can actually move forward. But it's this, if you're going to support the right to protest, and this is what I always say about free speech, about the right to protest, you have to be consistent. So, you know, I often talk about these self-styled right-wing free speech supporters who complain about woke culture but won't support women's right to free speech about their experience of violence. So free speech to say racist and misogynistic things, but not free speech to talk about your experience of gender-based violence. It's the same thing. Free speech to talk about Gaza, free speech to talk about COVID vaccines, free speech to talk about whatever the issue. We have to be able to support protest and speech about controversial issues and issues we don't agree with. That is what a democracy is.
And then so that when people go to vote in something like a referendum or something like Brexit, a year down the track or a couple of years down the track, they may have no vote remorse, which is something that we've been hearing about, you know, no voters in the referendum from last year being remorseful and recognising that they got it wrong.
I hope they do.
And Brexit as well. You hear a lot about Brexit. You know, voter remorse.
It's massive in the UK. The post. I mean, it's the first time I actually voted in an election. You know, I consider myself to be very Australian, and it doesn't matter how long I've lived in the UK. It took me a long time to start to feel like I had ownership over the politics there. But that was the time I decided to vote, was the Brexit referendum. And what we've seen from the consequences of that, the disinformation and the really misleading campaigns that were run by the Tories on Brexit, and the massive act of economic self-harm it is, the cost of living crisis we're seeing in the UK as a result of that. There's huge regret about that. And I think we'll see the same in Australia about that referendum. I mean, I've been trying to speak to people who voted no, and you would not believe when you sit down and actually speak to people, they didn't actually really understand what they were voting for.
Will laws that cover mis and disinformation stifle free speech?
Yes. And I have to say, this is where I am deeply uncomfortable about regulating disinformation, just because who determines the truth? Who fact checks? Who decides? And it's one of the most challenging issues we face right now, because the reality is we know that disinformation and misinformation is a huge problem. It was a problem in the referendum. It was a problem in Brexit. It's a problem in every single democratic election around the world. The use of online tools to spread disinformation, to undermine democracies, it is a massive issue. But the question is, we haven't found the right balance between regulating it and protecting free speech. And people are probably quite surprised that I sit more with libertarian right-wing free speech people when it comes to disinformation. So
if defamation courts are tying people up for speaking the truth, if there were mis and disinformation laws,
we will see exactly the same thing happen. And I think we have to be very cautious about how we do this.
So the media needs to just do better?
Well, the media always needs to do better.
Social media?
Social media platforms definitely need to do better. One of the things that we saw in the Amber Heard trial, and you couldn't really avoid it. I was in Australia. I wasn't even there. I didn't act in the US trial, but it was just unbelievable the way that it invaded social media, whether or not you wanted to see it or not. But the misinformation and disinformation that was spread about that was wild. And I actually contacted TikTok at one point because of some of the horrendous stuff that we were seeing online, and they just didn't do anything about it. And I think the platforms really have an obligation to in particular to better protect women, minorities from this kind of harassment, hatred and violence online.
We've just got a minute or so left. I know you've got some other sessions that you'd like to go to, but age restrictions on social media, that's something that we're talking about in Australia at the moment. Banning children from social media or teaching children how to use social media. What are your thoughts?
I honestly think that we need to have a media literacy program in Australia that teaches kids about different media sources and use of social media and how to interpret the world through the information that they're receiving. And I think that would be much better than banning kids from social media, that we should have media literacy campaigns in schools.
Jen, your name comes up so many times. There are so many huge global cases where, I'm talking to somebody from the Pacific Islands about climate change and their right to exist. And Jimmy Lai, who you're representing, how do you remain present in multiple places at the same time? You are like you have 5 minutes free and you meet with somebody about something that could potentially change their life and their family's lives. How do you do it? How do you give us a snapshot of how you run your life?
Being very good at multitasking. But also, I am just so motivated by injustice, and I love what I get to do. I love the impact of what I get to do. Being a lawyer is a great privilege, and to have the privilege that I have and the platforms I have to be able to do the work that I do to help people is so rewarding. And for me, it's energising, actually. But I have just been down the South Coast and have been surfing, and it makes me really, really happy. And coming home to Australia is what grounds me, spending time with my friends and family here, getting out into nature and surfing. That's what, other than being angry about the world, that's what keeps me going.
Oh, Jen, thank you so much for being Australian, for being one of us, for being here at South by Southwest. We've really loved that chat.
Thank you, Nerelda.
And there is a book signing. You can get Jen to sign your book just outside. You can ask some of the volunteers here, the staff, they can help you, direct you to where Jen's going to be doing your book signing. Thank you so much, Jen.